webinar series is aimed to giving you as an employee the tools to thrive at home and work in this time of the pandemic. So, let me go and go next. Hold on. Oh, here. Okay. I missed that one. So let's do a little bit of housekeeping. This does feature a chat, and it is turned on now. If you have questions about anything related to today's sessions, if you can enter it on the chat. And there'll be a question and answer at the end of the session, and we will dedicate that time at the end of the session to answer your questions. And so you heard the session is being recorded and will be made available within 24 hours from today. And lastly, I want to make sure you set aside for the next webinar, which will be Thursday, June 25th at 11 a.m. And the topic there is going to be chaos to crisis. And you can register for all of this on the Cornerstone. So I want to give you a little brief information about today's speaker. It's Laura Meyer, who's an attorney that specializes in California family, trash, special needs, and elder law. She's the author of a #1 best-selling book, Good Parents Worry, Great Parents Plan, and she's a co-host of a podcast, If Life Were Perfect. Laura has been a speaker for sessions hosted by the foundation, and that's how we found her and understand her expertise. And then I just want to make sure you're at the right session. You're at Getting Your Legal Ducks in a Row webinar. And I want to welcome our presenter, Laura, and you'll read more about the presenter on their website, which is would be listed at the end. And without further ado, I'm going to stop sharing my screen and we'll let Laura come aboard. Welcome aboard, Laura.
Thanks for having me. Okay, so let me get my screen up for everybody with the presentation. Okay, everything look good on your end? Hopefully now you're not looking at my desktop, but actually a presentation. So are we good, Liz? You could see it?
You're good. Yep.
Okay. Well, thanks for having me. It's fun to be with everybody. I always like being with people in person, but this is the next best thing. I kind of feel like we're all having coffee around my kitchen table. So hopefully everybody is safe and well. And during our time together today, what I really want to do is just help you understand what you need to do to be prepared. I think COVID caught everybody off guard. And we really saw firsthand and are continuing to see that when we don't have plans in place, how quickly things can change and how frustrating things can be when we're not properly prepared. So I want you and your family to always be the success story. And what I'm going to share with you today will really be crucial to making sure that when these life events come, whether they're public or personal, that you don't need to worry, that you are set up. So this is part of my team right there up at the top. And then down below, you can see my 4 kids. I do have to pat myself on the back. Not that I did a wonderful job, but I survived homeschool with the 4 of them and bought myself some sunglasses as my own personal present for the school year being done. Normally we buy them something, but this year I thought it was appropriate that I got the present. I own the Meyer Law Firm in Newport Beach with my husband, Josh, as Liz was saying. And really what we do is we help people when they're in the planning stage to make sure, gosh, if I get sick or I pass away, I'm set up. I won't have to go through courts. I won't have to go through a hospital nightmare. So we help in that respect. We also help if people have a kiddo or a loved one with a special need and might need some extra protections or unique protections. We also help if people are aging and they get sick and maybe they need daily assistance. We help them get vital government benefits if they need some support to pay for their care. And then we also help after someone has passed away. So if they did their planning, we can help administer whatever they had in place. And if they didn't do their planning, which won't be any of you, I know that's why you're here, but we can help with probate and those kinds of things to make sure that eventually the family can get an inheritance and sort those things out. So really, we're here as a trusted advisors and friends that our clients can count on no matter what they're facing in life and can kind of help the whole family. You already heard that we have the podcast, If Life Were Perfect. I also have the book, Good Parents Worry, Great Parents Plan. And then what I'm actually most proud of, well, besides having kids, is the 5 stars on Yelp. So I feel like we work with a lot of great families, and we're always thankful for their good experience. All right, so if you have questions, by the way, as Liz mentioned, just put it in the chat screen. I'll answer them as we go along. I'm happy to help with that. And I can't see the chat box, but you can, right?
Yeah.
Okay.
So if you've already come in, but they're a little early.
Yeah. So Josh is with me. That's the benefit of being married to your business partner during COVID. So he's going to let me know in the chat box when your questions come in, and I will be answering them. So I always like to start with a question. And it's, what percentage of Californians do you think have an estate plan? And if I could hear all of you shout it out, normally what people will say is like 10%, 25%. Someone's always like 2%, no faith in our fellow Californians. But it's actually kind of a trick question, because the answer is 100%. So 100% of us, meaning all of us, have an estate plan. And so you might be confused if you haven't set one up yourself, or yours is extremely outdated. All of us have an estate plan. And that is because if you haven't set up your own planning yourself, which we will talk about how to do, but if you haven't done that yet, California has a plan for you. And kind of a spoiler alert, you're not going to like it. So I'm going to show you what that plan looks like for your family. And then I'm going to show you some things you might want to do to make sure that you're not locked into California's plan, and you can kind of opt out and do things on your own and take charge. So this is the default plan. These are really the areas I'm going to focus on during our time together. If you have minor kids, or maybe you have grandkids, or nieces and nephews, we're going to talk about what happens to minor children if their parent gets, hurt or passes away. So we'll talk about guardianship. Then we're going to talk about probate court, which will apply to almost all of us who don't have planning. And then we'll talk about no control, California's plan with no control over the distribution of your wealth, estate taxes, a medical nightmare, and a lost legacy. So that's what we're going to focus on today with California's plan, and then again, kind of what you can do. All right, so I always like to start with the kids because if you are a parent, I know that's what's first and foremost on your mind. And so in California, if you do not legally name permanent guardians for your children, meaning you filled out the document, you had it witnessed, then your kids could be placed in temporary foster care if you get seriously ill or pass away. And then ultimately, a judge who does not even know your family will have to decide what happens to your children and who will raise them. And that is a very long, painful court process for the whole family. So there's actually a family a couple years ago in San Diego where this happened. The husband and wife, unfortunately and sadly, were killed in a car wreck, and they left behind 3 little boys. Those 3 little boys, instead of being immediately placed with family, because the parents didn't have anything in place or any emergency planning, they were placed in the care of strangers. And then for over a year, their mother's sisters, so the children's aunts, battled in court over who should be the guardian. And they were ultimately placed with one of them in a family that was torn apart at that point. So such a sad worst case scenario, and we don't want that to be any of us, right? We don't want our children to ever go through that. We don't want to put our family through that. And we want to make sure that if something happens to us, our kids are immediately placed with people we trust, and that certainly they're raised by the people that we choose. And so one of the things people tend to focus on when you set up a plan is they'll say, okay, I'm going to pick someone to raise my kids long term. That's great. And you need to do that. I've certainly done that for my kids. But a lot of parents, what they do is they overlook the short term. From the time you actually get hurt or pass away to the time somebody actually finds that document where you named a permanent guardian and puts it in front of a judge to approve it. Because ultimately a judge has to sign off on who you chose. So what happens in that gap? That's when we have to worry about temporary foster care and things like that. So one of the things that we always encourage our parents to do beyond just naming a permanent guardian down the road is we want to make sure from the second something happens to you that you're taken care of and your children are, and that there's a plan in place. So I always ask parents, like right now, if you're a parent, Who would your babysitter call if, you know, you were hurt or didn't arrive home from work? Who would make medical decisions for your kids if you were all injured? How would first responders know how to even get in touch with your relatives or friends if you were in an accident? And usually that's where parents get a little bit worried because they realize, gosh, we're leaving a lot of things to chance. So one of the best things that parents can do beyond naming that long-term guardian is to do what's called a kid's emergency plan. And you can see up on your screen, these are some key components of what a kid's emergency plan looks like. But basically what you do is you pick 4 to 5 family or friends who live in the area who can immediately come and get your kids to take care of them if there's an accident. You'd have emergency cards in your wallet. So if you are hurt, first responders know that you have minor kids waiting for you and they know who to call. You'd also have instructions to your caregivers and guardians on how you want your kids to be raised. Also instructions for who the babysitter would know to call in an emergency, in your children's healthcare history, and also medical directives for them. There was a public case up in Los Angeles a couple years ago where a husband and wife, again, were killed in a car accident, and they had I believe like the child was under 1, their child. The child was also hurt, rushed, to the hospital, and all of her medical care was directed by the state simply because obviously the baby couldn't articulate that her grandparents lived in the area. And so those are things where you're going to want to make sure you have them in place. Plus with medical directives for your kids, the best case scenario would be, hey, you're on vacation somewhere fun. And, when we were growing up, our parents would write the little note saying, hey, if our kid breaks their arm, so-and-so can treat them. Well, now, thanks to lawyers like me, right? Everything has to be so official and notarized and all of that. And so you do need to have official medical directives for your kids. Now, usually, I don't know, do we have any chat questions on the kids? Okay, so let me just take a look at your questions on kids planning before we move on. Just unplug it. Okay. So one of the questions that came in is, can you talk a little bit about grandparent rights? If one parent dies and the parents were not married, do the grandparents of the deceased have any rights to see their grandchild? So it's a bit of a family law question as well, but yes, in California, there are grandparents' rights. How much visitation you get would be determined by the court. And so that is something where if that is an issue, you want to talk with a lawyer. You also want to encourage your child, any of you who have children who are parents, right? You want to encourage them to make sure they're naming permanent guardians for their kids. And then too, when you do instructions to guardians, that is also a place where you can express who you want your child to continue to have contact with after you pass away. So it is critical, especially if you're a single parent and you're worried that the other parent might not facilitate that. It's really critical for you as the parent to write out, hey, this is who I want to remain in my child's life. I would want my parents to have visitation with my child and to document if they've had regular visitation. So that way a court can make sure that that could continue. Another frequently asked question a lot of people ask me is if they can't agree on a guardian with their spouse. And so there is, hopefully your attorney can help you, but there is a little process you can go to get on the same page. And one of the tips I give parents, because I know it's hard, I'm a parent too, and kids grow, guardians change, all of that stuff. You might not like who someone in your family married and now you don't want them to be the guardian, or maybe there was a divorce. But name a guardian for the next 3 years and then just know that you can revisit it. That way you don't need to peer too far into the future and wonder who's going to be around. So hopefully that was helpful. Again, if you have any more questions, you can put them in the chat box. Is there another one? Okay, so before we move on, if preferred guardians are not extended family, can extended family sue to overturn that? So yes, people can always challenge guardianship. One of the things that some parents do if they're concerned that somebody with bad intentions in their family or who would never be fit would try and get guardianship of a child and thwart the parents' wishes, you could always confidentially and privately exclude them from ever being a guardian. And again, that's only kind of revealed if they're actually challenging guardianship. But that is a way to kind of take the wind out of their sails and let them know that you're never going to be the guardian. But thankfully, we haven't seen too much of that. And again, the more you can set things up in advance and have that plan in place, and the less uncertainty and fighting that you will have. And so the ideal would be whoever you pick as guardian can immediately be able to step in, and they immediately be able to help facilitate contact with your family and people you want, and you need to document that that's what you want. And again, it's just a way to avoid any dilemma or any conflict within the family. All right, so just when a question comes in, if you could turn it around so I can read it. But I'm gonna move on now to our next portion. All right, so now that we've kind of talked about the kids, one of the thing, and this will now apply to everybody, so whether or not you have children or young children, but what happens to our assets when we pass away? Where do they go? And so some of you, if you're married, perhaps you'll own assets jointly with a spouse. If you're on a joint account, maybe it's going to go automatic to them. But if you're not on joint accounts, or if they pass away and then ultimately you pass away, eventually we say all roads will lead to probate court unless you do your own planning. So what probate court is a government process, a court process that your assets need to go through in order to get to somebody else. And it's really, if you haven't done planning, it's whoever your heirs at law are as determined by the court. So even if you have a longtime partner, you're in a relationship, if you didn't own the assets together and you pass away, it's not going to them. It's just going to go to whoever your next of kin is as determined by a family chart. So that's something where everyone needs to make sure that they're addressing where they want their assets to go, and making sure they're not getting locked in a court process. So let me give you some key characteristics of probate, a little glimpse. If you've been to traffic court, imagine it 100 times worse with a lot of tears. Probate court is a court process. It's 18 to 24 months long at a minimum in California. And that's if there's not a fight and it's not contested. It is open and public, so anybody can see what you have. That's why when a celebrity dies without estate planning, why we all know what they have, because it's open and public. I think of Prince when he passed away, we could see everything about it because it wasn't private. There's no control over, again, who your assets go to. It's just the defaults. The money will eventually, when probate is closed, go outright to your next of kin. So let's say you have, like, your children were your next beneficiaries. Because they're children, your probate nightmare doesn't quite end, because that money has to get put into blocked accounts. And then every other year, whoever the court put in charge of that money has to go back to court and show the court how it's being used and spent and managed. And then on the kid's 18th birthday, it's outright without any restrictions. And so that's where you see large sums of money going to very young, inexperienced kids. And the kicker is probate is extremely expensive. It will cost you 10 times more to go through probate than it will to set up your planning on your own, which is kind of ironic. As difficult as California makes the probate court process, they make it so easy to avoid. And I'm going to show you how to avoid it. One thing I wanted you to know, and you can see it in red at the bottom left of your screen, is that during our California stay-at-home order, our courts were actually closed, and they're just now slowly opening up with major backlog. And so one thing we learned from this crisis was we can't always count on the court system to be available. And so for a lot of people, if they had something go wrong or somebody passed away, they were out of luck. We couldn't even go to court during that time. Or if they were waiting for, if they had a case already in the hopper, everything was just stayed and put, delayed. So again, we can't always count on the court system to just be able to accommodate our individual needs. And if you're stuck in that system, you just have to know that it's not going to be a smooth one. And so back to court, if you're curious about how expensive it is, this is a sample chart of what probate could cost your family in California. We are one of the most expensive, convoluted court processes for death in the nation. So California, when they calculate the fees, it's all set by the probate code. It actually starts out at 8%. They'll take 8% of your total estate worth. If your estate climbs value towards the millions and beyond, that percentage will come down. So when I speak, I like to give about a 5% estimate of what probate could cost a regular family. So they go off the fair market value, meaning even if you have debt, you have a loan on your home, anything like that, they're calculating their fees based on what the asset is worth, not what the equity necessarily was. So for your home, let's say if you sold it tomorrow, it would be worth $500,000, but you owe a mortgage on it and it's, you know, a loan for $400,000. If you died, they would calculate the fee just based off $500,000, regardless of the loan. So in this family, they have the $500,000 for the house, the bank account's 20, retirement and life insurance, a little over $1 million, and personal belongings, 25,000. So their estate is 1.645. And their cost of probate here is $82,000. And I know it's shocking how much people pay for probate. Now I put an asterisk by the retirement and life insurance because normally those are accounts where you can just name a beneficiary and it'll avoid probate because it'll go directly to that person. The challenge is if you name a minor child on there, that's how it gets brought into probate because, you know, MetLife can't just cut a check for $1 million to your child. But what we typically see anyway, as kids are raised, people's assets go up. So most people, this would be in the realm of what they're dealing with. So you can calculate in your own mind what probate might be. And I'm sure you're not going to be happy about that cost. Do we have any questions on that?
No.
Okay. All right. So how do you avoid probate, right? Because nobody wants to go through probate. When I have to tell people after someone passes away, when they come to me and say, you know, hey, I found you online and, someone in my family just died yesterday and they're lost, I have to break it to them that they're going to have to go through probate. And they usually say, can't we set up a trust? Well, that time is obviously past. You have to do that when you're living and you have mental capacity. And so that is the way that you avoid probate in California. You set up what's called a revocable living trust. So what a trust is, it's a private legal document that your attorney prepares. It basically says, this is who I am. This is who I love. This is where I want my money to go if I pass away. And this is who I trust, my family member or my friend to manage it and make sure that this happens. It completely avoids probate if you've set it up correctly, you've kept it up to date, and you've made sure that all of your assets are connected to the trust. It will completely avoid probate when you've done, you've actually properly set it up, which is far more than just signing a document, tucking away, and never thinking about it. What it also does is during your lifetime, it holds all your assets. So think of it like an open box. You put your home in there, you put your bank accounts, you can put your life insurance policy. Let's say you sell the home while you're living, it automatically goes out. You buy a new home, you buy it in the name of the trust, it's all in there. Whatever's in there when you pass away, lid closes, passes probate free. I think, and we can get into kind of things where things go wrong, but so oftentimes, what happens is people are forgetting to continue to put their assets in there properly, and that can create a bit of a mess. And that's where really working with an attorney who's helping you continually do that makes a huge difference. But a trust really does, like it says on the screen, it does make life so easy for your loved ones. It is always, always chaotic when somebody passes away. It is always sad and devastating, even when it's expected. There's always an opportunity for family to come together and always a million good reasons why they shouldn't, a lot of things against them. And so having this in order, saying what you want in advance is critical to preserving peace in the family and critical to making sure that money's immediately available for your burial, for anyone that was relying on you, like your kids or spouse, making sure that they have that money continuing to come in until things can kind of be doled out. And so really that's what a revocable living trust can do. This is kind of taking a look inside a trust. And if, probably a lot of you are professors, so you probably love the educational aspect of the inner workings of a trust. Others might not even like looking at a chart, but you can see here kind of how a trust flows when somebody passes away. So at the top of the screen where it says family trust, that's where, everything is held during your lifetime. Now, if you're married and one of you passes away, like, Mike and Sarah, right? They have Mike's half, Sarah's half. You have an option there when you set up your trust. Do you want everything to just go outright to your surviving spouse, where they're free to get, keep it, get remarried, give it away? They can do whatever they want with it. Or do you want to protect it? So in this case, and I always kill the husband off because it's less emotional. I'm only kidding. But let's say Mike passes away. He can give everything to Sarah. She can get remarried. She can change beneficiaries. It doesn't even have to go to the kids upon her death eventually. She has that freedom to do what she wants with it. If she's getting sued, it can be taken after Mike's death. Or Mike might say, gosh, I love Sarah. I trust Sarah. I want her to have full access to my half of the money, but I don't want her to be able to give it to a new spouse. I'd actually want her to have to sign a prenup if she was getting remarried to continue to use my side of the money. Mike would also set up where Sarah can't give away his half to other children that may come in her life. It would only have to go to these kids that they had together, or whatever beneficiaries they chose. Or maybe Sarah's getting sued down the road. And so in that case, they could go after Sarah's money, but not Mike's, because that's in an asset, protection trust. So you have those options when you are married on how you want to set it up. And that's where your attorney can help you work through the pros and cons. Same concept down below. Eventually, when both parents pass, it goes to the kids. Traditionally, it was just, okay, give it outright to your kids when they turn 30, regardless of what's going on in their life. But a lot of people found that structure might not be best for them. For some, it still is. And again, it's a personal choice depending on what's going on with your kids. But you do have the option to protect that money for your children's lifetime. So it can't be taken by their future spouses, creditors or predators or anything like that. And then also, certainly if any of your children have a special need, you can set their share into a special needs trust. So that way they can get important government benefits when they're an adult and won't be disqualified because you've left them money. So what's great about a trust, and really the takeaway is, 1, it avoids probate. 2, it makes the money immediately available, privately, efficiently. And 3, it's going to flow down and be managed exactly how you think is best for your family. You have all of those options. So a trust truly is a wonderful way to go. And just so you're aware, in California, to be subject to probate, you have to have about, is it 150 now? 162 now is the amount. You have to have $162,000 of assets. So if you're not there for some reason, a will could potentially work for you, but for most people, they need a trust. I want to stress, because this is a common misconception, a will does not avoid probate in California. A will simply says, hello, judge, this is where I want things to go when I pass away and who gets my money. It doesn't actually avoid the fees or the actual court process of probate. Only a trust can do that. Okay, any questions? All right, so we've got a few questions now on this. Again, if you have them, go ahead and put them in the chat box. Why would someone go through the probate process to be a guardian of a child if the parent is still living? Why not family law? I'm sorry, 1 second, what's that? Yeah, okay, why would someone go through that is a family law. So you would only go through the probate process if there was like an estate, if a parent had passed away. That's the arena you would go to for guardianship. If you're going to obtain guardianship and everyone's alive, that would be family law. So just different circumstances. Should life insurance be included in a trust? Have heard yes and no. I have a joint account with my daughter. Will there be a problem if it's not in a trust? And again, the disclaimer is I'm not giving anyone individual legal advice, but life insurance can be in your trust. And a lot of it depends on if you're doing asset protection within your trust, where you're doing those restrictions. Like we talked through Mike and Sarah, where he didn't want Sarah to just get remarried or give it away. If you want rules on that money, the rules of your trust to apply, you're not going to just give that life insurance policy straight out as a, transfer on death beneficiary. You're going to want it to go through the trust because that way those rules are going to apply. And then, but just so you're aware, the ownership of that policy remains in your name. So we're just talking about upon a death. And then in terms of owning a joint account with the daughter, here's why I highly recommend you do not do that. When you own anything joint, it means that if you pass away, what's nice is it automatically goes to that person. But during your lifetime, if either one of you has a creditor, a predator, a divorce, a problem, they can go after that money. And so one of the problems we see people do is they make things joint and not realizing then it's subject to that other joint account holders, creditors and predators and all of that. So there's definitely better ways to do that. And your estate planning attorney can actually help you figure out, okay, why do you want that account together? And then what's the better option? Okay. And I see that there's some more chats in here. So let me read them as they're coming in. Any changes, recommendation when kids turn 18, documents needed? Yeah, that is a great question. Once you have children, that turn 18, at that point, they're considered legal adults under the law. So they need to set up their own planning. And usually what they start with when they're 18 is their medical directives, which we'll talk about, where they're saying, yes, my parents can continue to make medical decisions for me, even though I'm an adult now. And then also they can do a power of attorney. So you could potentially help them manage their money. And so that can be done when they're 18. I actually did a podcast episode and I was on the news recently talking about the college must list. So that would be great for any of your students to see at OCC, talking about what documents they should have in place. And so I can put the link to that. I'll put it in the chat box. I'll find it. And we'll be able to send that to you in case you want to check it out. If you're, okay, so okay.
Laura, just a quick, I just put it in the chat. If anybody has personal situations that have a lot of details, I just remind everyone the chat is public. And at the end of this, I'll be posting all these links of how you can contact Laura and some other information. So yeah, just to remind.
Okay, thank you for that reminder. If you have everything in a trust and you were sued, is that trust protected? Some are, but the type of trust that we're talking about today, a revocable living trust, that is not protected from lawsuits during your lifetime. You can set it up though, where after you pass away, money can go into what's called irrevocable trusts, which could be protected. So again, it depends on the trust. I'm going to go ahead and some of this is a little bit private. And so I'll have to get to those. I'll give you a chance to talk with us and Liz will give you guidance on how to do that at the end of it. So some I'm going to skip through for now. Can you update your trust on your own if the lawyer who set it up is no longer practicing, and where does one file the updated forms? So revocable living trusts are private. They're not actually filed anywhere. And I would highly recommend if you have a trust and you can't go back to the lawyer, to establish a relationship with a new attorney to help you amend your trust. It is actually a technical and legal procedure to do that. And so you would definitely need to go through a lawyer to do that. Why have a will if you have a trust? Is a will still needed? Yes, I'm really glad that you asked that, Dan. When you set up a trust, you also set up what's called a pour over will. So it's not a full will, it's just a pour over that says, if I forgot to put anything in my trust, I wanted it in there. So when you pass away, we can open up a more modified probate, tell a judge that's what your intent was, file that pour over will, and then we can bring your assets into your trust. And so that's why you will have both. But again, think of that pour over will like a safety net at the circus when the dancers are doing the tightrope. We don't want them to fall, but we're really glad that net is there. It's messy, it ruined everything, but they're gonna be okay. So that's what that pour over will does. So you would have both. All right, so I love all these questions. I wanna make sure too, we're gonna get through these. So let me get back to the presentation, and then Josh will help me with some of the more that are coming in. So those are kind of, again, these questions you're asking are great, and I'm going to give you a chance to talk with me privately too about your specific situation. And thank you, Liz, for reminding us too that it's public, the chat box. Okay, taxes. Moving on, we talked about guardianship when we had that chart. We talked about guardianship. We talked about probate. We talked about no control over distribution of wealth when you go through probate. And now we're talking about taxes. So will your family owe taxes? And so right now in federally, you can pass as an individual a little over 11.58 million upon your death without any taxes being owed. Estate taxes being owed. And then if you're a married couple, it's 23 million. So if you have an estate tax problem, congratulations. I'm sure OCC would love to accept your charitable donation. But if you have issues with that, there's over 200 techniques we can do to help reduce or eliminate taxes. A lot of that's done through charitable causes. Most people aren't going to have an estate tax issue, but keep in mind that exemption changes. So during the 90s, we were seeing it at 600,000, and that was it. And then estate taxes would be owed. And so one thing I tell people when I meet with them and set up their trust is no matter how much time we spend together, I'm never going to know when you're going to die, how much money you're going to have when you die, and what the estate tax exemption will be, right? Because we just don't know. And so you need to make sure that your attorney, when they're drafting your plan, is keeping it flexible. And that also you have that continuing relationship, because if the estate tax exemption changes, you need to make sure that your estate plan is keeping up as well. The more common taxes that we tend to deal with is more along the line of capital gains and people getting a step up in basis is what it's called when somebody passes away and then they want to sell the property. I'm not going to get too much into that, but what I want you to know is the capital gains issue is very real in how it affects people when they pass away. And you really do need to consult with an attorney to make sure things are set up properly, especially let's say you have an elderly parent and they're in that time period where they want to go into a home and then sell the family home, but that will also affect inheritance issues when they pass away and capital gains issues. So there's not a right or wrong or a magic formula, but it's sitting down and getting that individual tax advice to know what's the best way to meet our goals and then how to structure this to achieve them. Now we're going to move on to medical nightmare. And wow, what a medical nightmare it has been during COVID for so many of our families. You know, I obviously have given this presentation a lot live before COVID. I had no idea just what a medical nightmare it would be. So during this time with COVID, as you may have heard or hopefully not experienced personally, but our hospitals were shut down to visitors. We had clients, we had friends who in their words, their loved one died alone. And that is how they felt. We also had friends in the medical community, physicians who assured us that no one dies alone and they are getting a lot of love, but the reality was their family could not be with them. My son actually had to have an emergency procedure during COVID. So I saw firsthand what the inside of the hospital was like. I was only allowed in, just me, not even my husband, only one parent. And I sat alone. I did not see a single person for 7 hours in the waiting room because nobody was allowed. And so one thing that we realized with this medical nightmare is if you did not have your wishes in place and you had not specified exactly who the hospital should be talking to get direction, your family was out of the loop. And perhaps some people's medical wishes were followed and some were not. It's not a criticism on the hospital. In fact, I will tell you personally, on a side note from being in the hospital, in the recovery room with my son, just how much love and support every patient was getting from the medical community. So that was touching to me to see firsthand. But really, it was a doctor who went viral who pleaded with people to get their medical directives in place. I think it was, I don't remember the city, but they said out of 50 patients, only one she had even had a directive in the COVID unit. And that puts pressure on them to try and decide everything you may or may not want, especially with a ventilator and things like that. And so one of the things that we recommend is, well, really, I want to plead this on behalf of, your family, the medical community, all of us, your colleagues, get your medical directives in place. Declare who you want to make those decisions. Make sure that you've said who can get information on your condition if you are incapacitated or out of reach or can't be accessed because you're in a shutdown hospital. Under our HIPAA laws, your medical information is private. Nobody can get it unless you've expressly authorized through legal documents to share it. So make sure you've done that. Specify your end of life wishes. What do you want if you're on a ventilator and you won't recover? What do you want to see happen? And the other great thing is when you have your directives, your family is not going to be turned to run into court, which again was shut down, to try and get authority to make decisions for you. And so please make sure, one, you have all your medical directives, and two, that they're accessible. It's no good to have medical directives that are locked up in a safety deposit box and you're ending up in the hospital. What you need to do, and especially right now with the way the hospitals are, this is what I'm recommending. One, file your directives with your local hospital and your primary care physician. But two, have a copy in a manila envelope. If you are sick, if you have to go to the hospital for any reason, I want you to physically go in with those documents on you and make sure that whoever you've chosen to be in charge of your medical care or who would be the most likely person to take you to the hospital knows exactly where that is. So, and then your attorney should also have a copy of directives. And that was critical, how many calls we got from clients who had a loved one in the hospital who needed us to help them navigate this ever-changing, unusual situation. And so that's something, and this I'm not legally recommending, but it's just a tip if COVID continues to limit visitors. But it seemed that people who did have people on their directives that had medical clearance and could get into hospitals, it was a little bit easier experience. So to keep that in mind. Okay, so that is my plea for you guys for medical directives. One other thing I want to note about an incapacity, not just medical, but financial as well. If you are incapacitated for any long or short period of time, you want to make sure that your family can continue to be provided for, that bills are paid, that your financial support is continuing. And so having a durable financial power of attorney is critical. It's a legal document that allows someone you trust to act on your behalf financially during an emergency. And it also avoids the need, again, of them having to run into court to get that power. Finally, we've talked obviously about the guardianship. We've talked about probate, no control over distribution of wealth, estate taxes, medical nightmare. Now we're going to talk about the last thing, which is actually the most important thing. Don't forget to preserve the most important asset of all, and that is you. You are the most important asset of all. You and what you mean to your family. I have yet to ever have someone, a client, a friend, when I say, how are you doing after they've lost a loved one? I've yet to have someone say, oh, well, I'm really glad I got that timeshare. No, they're missing the person that they lost, the person that they love. And so one of the things that we recommend that you do for your family is that you take time to do what's called a legacy interview. And what a legacy interview is it's you talking on audio or video to your family, telling them, preserving your special memories, your wishes for them, talking about your values, what's important to you, providing comfort to them, and just saying, I love you. We had a client, he was married, 3 kids. He came into our office to do his planning just to be a good dad. And we found out a couple months later when he did that he was dying of stage 4 brain cancer. Very unusual, but he was dying. And so when I went to click on his legacy interview, I don't listen to them, right? Because it's private. But when I was checking for them at their request to make sure everything was perfect on that, I happened to click on a part where he was talking about each of his 3 very young children in detail. And he was saying what's neat about them, what their strengths are, what he thinks of them in his own voice. And one thing he said, which I thought was interesting, is he said, the one thing I will say about my kids, I know that they are very strong kids, and that no matter what comes against them in life, they will overcome. And I thought, wow, these kids will never know their father. Their mother will tell them about their father, as will the family, but this really was the only chance, this legacy interview, for them to hear their father's voice describing them and expressing his confidence in them, that he saw they were strong and that they would overcome no matter what comes. To me, that was such an incredible gift, a priceless gift for his kids. And the family felt the same way. And so he did pass away, and that is something that his children will always have. So take time to do that for your family. Some people will say, especially I feel like if people's kids are grown, they're like, oh, they don't want to hear that. Guess what? Maybe they don't, but they want their kids to hear it. They will say, gosh, I wish my son or my daughter could have met my mom or just heard my mom's voice one more time. Take time to capture that. If not for them, for the grandkids, or even if you don't have the direct family line, your siblings, your family, the foundations that you are involved with, telling them you love them. This is a priceless gift that everybody should do for their loved ones. So here is the wrap up. This is your current plan. If you have not done your own planning, the recap is your children could be in foster care and a judge would have to choose guardians. Your family would go through a long and expensive court process known as probate. You have no control of your distribution of wealth. It's just going to go to your next of kin and outright at 18 for any minor kids. Estate taxes, not so worried about, but it could become a problem in the future, and we're certainly concerned about capital gains. A medical nightmare, stressed, and a lost legacy. So how many of you sitting at home right now like your current plan for yourself and your family? Probably nobody. And so the good news is hopefully what you've seen is you do have the power to change everything. You really, we can't control what happens to us. Obviously, we wear a seatbelt. We try and now wear face masks and social distance. But we can definitely mitigate the fallout and be there for our family, even if we're no longer here. And that is done through proper planning. So this is what a good estate plan looks like: kids emergency plan, a revocable living trust, asset protection, if that's something you think your family needs, charitable giving to help. And again, even if you don't have an estate tax issue, charitable giving is one of the most beautiful things we can do while we're living and when we pass away. I've learned that from my clients and watching the joy it brings. Medical and incapacity care. So you'd be totally taken care of if you did get sick, especially right now during the pandemic. And a preserved legacy. That is what a good estate plan looks like. And that is something that I hope that you will do for your family. So 2 frequently asked questions, and then I'll get to your regular Q&As. We have about 10 minutes left. But the big question people always ask me when I was speaking that I now have part of my presentation is, do you need to even work with an attorney to set up your estate plan? And the answer is no, not everybody does. And so really, you only need to work with an attorney if you own more than personal belongings and wouldn't even be subject to probate. So if you're renting and you really don't have assets more than $150,000, you're just kind of starting out, you might not need necessarily to work with an attorney. But certainly if you have children, if you have any dependents on you, or if you own real estate, or you have more than $150,000 in assets, you definitely need to be working with an attorney. If you want the ease of knowing that your money will go efficiently and smoothly upon your death without having to go through a court process, you really need to work with an attorney to help you set that up. And then if you want confidence of knowing your plan was prepared by a professional with a fiduciary duty, you need to work with an attorney. There's a reason why the online drafting platforms and then, the discount paralegal things you see on Craigslist, there's a reason why they're disclosing constantly, go get this reviewed by an attorney, go to an attorney, because they're saying we don't have a legal obligation to make sure any of this would actually work. And so if you want to make sure that somebody has an ethical fiduciary duty to make sure your plan works, you need to work with an attorney. And then two, if you want to make sure your plan stays up to date, that you have somebody to turn to in your time of need, it is great to have that relationship. I will tell you, especially during these past few months, the benefit people felt from being able to call somebody who's not a player in their situation but can help. It is huge to have that relationship with your attorney, so you're no longer navigating life alone. Even simple things like you want to buy a new home or sell something, just to be able to call your attorney, or maybe you're refinancing. It's nice to be able to call your attorney and say, what do I need to do? How do I keep it up to date? And the biggest thing, is having someone to turn to in your time of need. That's if you should work with an attorney. You also want to make sure that the attorney you're working with is bringing all of that to the table, because not all attorneys are alike. And so you do want to make sure that you're not just getting documents and a goodbye, have a good time, I hope that works out. You want someone that's actually going to be like an attorney you can turn to now and for the years to come. The second thing, and there are many great attorneys in our area who provide that. The second big question people ask me is, what should estate planning cost? And so you will see such a range of what estate planning would cost. So first, before we answer that question, is what does it cost not to plan? Tens of thousands of dollars. If your house, again, only has a market value of 500, you're talking about 25 grand in legal fees just for probate, plus the hassle. So it's incredibly expensive not to plan. You will see when you go to evaluate estate plans, like the cost, and you'll get quoted things from 1,500 all the way up to 10,000. A lot of it depends. And so here's the question I need you to ask when you're interviewing an estate planning law firm before you hire them, is before you ask, what does your service cost? Ask, what does your service include? Because it is not all the same. I'm going through this right now, just trying to get simple garage cabinets for my garage. And I've been quoted all over the place. And really, that's where it really helps to know, what am I getting? What am I actually getting? What do I need? And is this a fair cost? That's the only way to evaluate it. I will tell you that most reputable estate planning law firms in California, especially in Orange County, to get kind of that full experience planning that I've talked about today, and making sure you are avoiding probate, you have the trust, you're making sure your family has someone to turn to, you have asset protection options or special needs planning if needed, all of that. You'll see a range between $4,500 to $6,500. So if you're getting quoted below or above that, it's just kind of a red flag to dig deeper to find out really what are you getting. And then the big thing I want you to ask too when you're interviewing law firms is talk to them about their ongoing maintenance costs, because what happens is you might set things up, but again, it needs to keep up with you. And if you do need to make, change a guardian, or you do have a question about buying a home, you need to find out, what does it cost to talk to that attorney to keep things updated? That's where things can really start to add up and people get frustrated. So you don't want just, here's some documents, you pay this premium price and you get sent on your way. It's not going to work for you in the long term. And so that's something you want to ask. Now, my understanding from Rebecca and Liz is that you guys do have, several of you have access to Hyatt Legal Services. And so Hyatt is a program where they will have some attorneys that you can go to set up your planning that will potentially be covered. What we've typically seen, though, is that it's not going to be at the level of planning that most people are interested in. It tends to be more document-based. Again, it depends on the attorney. But one thing that's great about Hyatt is some firms will accept your Hyatt legal program as almost like a copay to help towards their costs. And so even if you're not using a Hyatt attorney, or you need something a little bit better and more sophisticated, you can still ask the law firms if they'll at least you'll be able to get reimbursed through Hyatt for some of their fees. And then really who I recommend Hyatt for is really people who don't necessarily need to work with an attorney. Maybe it's just a will-based, they're just starting out, they don't have kids, they are renting, but they want to make sure they have their medical directors and power of attorneys and a simple will. That could be great to start with a Hyatt program. So if you're not sure, that's something I'm happy to talk with you about to help you understand what level you might need to be at. But that is an option for you. So that's kind of everything. So now I want to do your Q&As. Right before I get to that though, is if you have a question you want to ask me privately, or if you want to find out what kind of planning you need, I'm happy to talk with you directly. And so one of the things that we're doing for OCC is we have set aside some free planning sessions with a member of our team. Now, of course, when something's free, there's always a catch. And don't worry, you don't have to take any of my children. But the catch is we really do need you to reserve that planning session within the next 48 hours. The reason being is I have to be able to free those up for the ones that aren't taken to the next group that I speak with. And so if that's something you are interested in, Liz and Rebecca are going to put the link to schedule for that in the chat box. You're also welcome to call. I think earlier the area code was wrong on the phone number, but this is actually our phone number. It's the 949-718-0420. You're welcome to give Bonnie a call at the office and she can help schedule you a session, but we're happy to extend that to you. It's really for people who have been wanting to do their planning and they really just need to sit with a reputable attorney and find out what they need and understand their best options. That's definitely something we would encourage you to take advantage of. We're also putting a link in the chat box. If you would like to download a free electronic copy of my book, Good Parents Worry, Great Parents Plan, it covers a lot of the information that we talked about today in the workshop. So you're welcome to sign up for that. When you go to that link, just scroll down to the bottom of the page and you'll be able to sign up. All right, in the last couple of minutes, we have about 3 minutes left. I'll answer a few more questions, but again, you're welcome to talk with us directly if you want. So what questions should I? Okay, so we're just getting those queued up. Okay. Does an estate planning attorney know about taxes, inheritance, transferring title of the house, etc.? I hope so. Yes. If they're an estate planning attorney, they need to know about that. And so that would be a good person to talk to. Sometimes people, there's a crossover between just real estate attorney and estate attorney. What's good is that they'll know if a different type of attorney should be answering it. What if we outright own our home? Is a living trust necessary or no? Yes, absolutely, because regardless of whether or not you have a mortgage, you need to determine where your property goes when you pass away and avoid probate. And so a revocable living trust is the best way to do that. Any other questions? Okay. If you list a beneficiary in all bank accounts, would you still need a will and trust? Great question. If you're naming like a transfer on death beneficiary, you don't have any minor children, you're giving it all to one person, that is potentially a way to do that. The challenge with some of that, with not having a will and a trust, is more so what if they're not there, or what if they were hurt along with you. So that's where you start to, things get dicey. And so ultimately it's always best, if you do have those kinds of assets, to have a will and a trust in addition to that. Plus, you're going to need all your power of attorneys if you're incapacitated, not just passing away. Can you buy a house in a land trust in the name of that trust and add it to your living trust as an asset? We don't do land trusts in California. So there's other types of trusts that would be more favorable. Someone just asked me that the other day, actually. So that seems to be floating around, that concept. Okay, anything else? Okay, well, we're at 12 o'clock now, and so I'm going to answer one more, and then we're going to wrap up. If a husband and wife co-own a home, does a home go through probate after death of one or the other? Potentially not, depending if they were both on title and how they owned it. It could be avoided upon the first, but again, you know what happens in that case is sometimes that then affects capital gains issues when the second spouse dies. So you want to be able to have that addressed to begin with, just to know how that would play out, and talking with an attorney would be able to help you. All right, well, it's 12 o'clock. I want to thank you so much for having me, and I'm assuming Liz or Rebecca will want to hop on soon. But again, if you have those questions, go ahead and take advantage of the free session, download the book, whatever you need. My understanding is OCC will also have this presentation uploaded in their portal if you want to view it, especially with your spouse. But whatever you guys need going forward, I'm always happy to answer questions for you and provide you that information. I hope I could, whether or not you're my client, I'd love to be a resource for you going forward. So thanks so much for having me today.
Thanks, Laura. And so I see from Rebecca will send everybody an email with all the links. So your email will have all the links that you need. And I just want to thank you, Laura, and and your lovely able assistant husband for making the time to help with this conversation. Again, these series are brought to our employees as a way to support all of us as we navigate through this pandemic and figure out what is exactly we're real concerned about. And I'm thank you also personally for bringing up about the pandemic and the healthcare issues that are unique.